Thank you everyone for joining us today. There is a handout in addition to the slides that you'll be seeing during the webinar, and that will be sent out in due course. By way of introduction, the webinar will provide an overview of Article 8 case law, some recent, some well established, and address the practical effects of these developments within Appendix FM and wider Article 8 arguments. It's difficult to cover everything in the time allotted, so I will be focusing on the section that I probably encounter most, which is EX1B, partners under Appendix FM. I will also touch upon some cases on children and section 117B6, and then turn briefly to the decision of MY, which involved a victim of domestic violence. Jamil will then talk about case law dealing with wider arguments on Article 8 and how to help you tip the balance in your favour. So we begin with the test of insurmountable obstacles in the rules. EX1B gives you the possibility in an appropriate case to avoid some of the strict requirements in Appendix FM. I'm sure that many of you are familiar with Appendix FM, but I will spend just a little time to highlight some of the nuts and bolts of the rules for those of you who are not. Appendix FM sets out the requirements for partners who wish to enter or remain in the UK. So we start with section General Gen 1.1, which states that the route is for those seeking leave to enter or remain on the basis of their family life with, for example, a British citizen or a person who is settled in the UK, and so on. It also talks about how the rules reflect the balance to be struck between competing interests. So on the one hand, you have the individual with right to respect for private and family life, and on the other, the public interest considerations. Gen 1.2 defines the term partner. That's set out in the slide for you to read. And then next, we have the requirements for limited leave to remain as a partner. And when considering leave to remain, there are two ways of satisfying the requirements. Both ways require the parties to be in the UK and not to fall foul of the suitability requirements. The appellant can succeed by either meeting all the requirements of ELTRP, or you can satisfy the relationship immigration status requirements and show that EX1 applies. The immigration status requirements are set out in ELTRP 2.1 and include, for example, that you must not be a visitor, and the one perhaps that most of us will encounter, that you must not be in breach of immigration laws unless EX1 applies. You then have section EX, exceptions to certain eligibility requirements. We will have a quick look at children later, but for partners, EX1B requires insurmountable obstacles to family life with that partner continuing outside of the UK. So what does that mean? EX2 defines insurmountable obstacles as very significant difficulties which would be faced by the applicant or their partner in continuing family life outside the UK, and which could not be overcome or would entail very serious hardship for the applicant or partner. Turning to the case law and how this is all interpreted, we start with the case of Lal, where the court considered the test under EX1 and examined the level of detail that should be provided in support of such a claim. The facts were fairly straightforward. The appellant was an Indian national and a student, and she married a British citizen prior to the expiry of her leave. So she was still in the UK lawfully when she made her application to stay based on her relationship. The only issue raised in the refusal was whether the relationship was genuine, and this was subject to a positive finding in her favour by the tribunal. The tribunal then went on to consider EX1 because the appellant was unable to meet the financial requirements under the rules. The factors said to support insurmountable obstacles were the partner's age, he was in his 70s, his ties in the UK, and that he was unable to live in India because of the heat. So his evidence was essentially that he would not go and live in India. The appeal was allowed by the First Tier Tribunal, but the Secretary of State appealed successfully to the upper tribunal, and permission to appeal was granted by the Court of Appeal on whether the test was subjective or objective. So paragraph 36 of law deals with the test as a series of questions. So first, whether the obstacle amounted to a very significant difficulty. Next, whether the difficulty made it impossible for family life to continue outside the UK. And third, whether it nevertheless entailed a very serious hardship for the applicant and or the partner. The court at paragraph 37 considered the question of whether there was very serious hardship as essentially one of fact. There needed to be a detailed examination of all the facts, consideration of the particular characteristics and circumstances of the individual, and also whether there were steps that could reasonably be taken to avoid or mitigate the difficulty. It expressed some doubt about whether it was actually necessary for the appellant to have shown EX1 applied, where the Secretary of State's reasons for refusing the application were limited to whether the relationship was genuine and subsisting. As to whether the test was subjective or objective, the court considered the test was not subjective in that it was not enough for the individual to simply show that they would perceive the difficulty as insurmountable, because that would give a person who is less resolute an unfair advantage. What was required, and this is in paragraph 38 of the judgment, what was required was a detailed examination of the facts, and paragraph 38 considered a number of questions that should have been asked in the assessment of whether there were insurmountable obstacles, and explains the level of detail that was required. Just as an example, if the couple had to move to India, where in India could they reasonably be expected to live? What were the average temperatures? What steps could be taken to mitigate the heat during the hot weather? In this case, the Court of Appeal considered that the upper tribunal was correct to find an error of law in the First Tier Tribunal's decision, because it had failed to undertake the factual inquiry that was required. But the Court of Appeal were also critical of the upper tribunal judge and went on to find that it had also made an error of law. Paragraph 41 of the judgment, the court considered that the upper tribunal was wrong to suggest that a very serious hardship could not be established without medical evidence. This was in the context of the appellant's partner, referring to his difficulties with exposure to heat. There was also nothing wrong in principle in basing such a finding on the appellant or his family members' evidence, if the evidence was sufficiently compelling. Where the upper tribunal was said to have fallen into error was by failing to consider the cumulative impact of all the factors. This is often a common error in my experience by the Home Office and the tribunal, where factors are considered separately, but then there's a failure to conduct a global assessment. So in law, this would have meant considering factors such as his age, his sensitivity to heat, and personal ties together, and then asking the question whether there would be very serious hardship. Moving on from Lal, I've referred to other cases just to give examples of some of the factors and arguments that could be put forward in support of there being insurmountable obstacles. And so you have AAAP, which was a judicial review case where the appellant was a Ghanaian national and his British citizen wife had several medical conditions. Detailed medical evidence was presented alongside the appellant's own research into the lack of medical care available. The First Day Tribunal appeared to have found that the appellant's wife could remain in the UK, but then did not go on to resolve the basic question of whether there were insurmountable obstacles given the couple's separation. There appears to be a common theme running through many of the cases where the court is at pains to explain that the insurmountable obstacles test is not a proportionality assessment, it's distinct. And in AAAP, the court cites paragraph 45 of the Supreme Court decision in Aguiarco to make the point. AA is also useful as a reminder that immigration control considerations are irrelevant to EX1. And this was a point that was conceded on behalf of the Secretary of State. This makes sense because if you only reach the point of considering, this makes sense because you only reach the point of considering EX1 because you don't satisfy all of the eligibility requirements. Moving on to ASAP, this is a further example of matters that could support a claim. This was a judicial review of a refusal of a fresh claim and a case where the court was obviously not assessing whether the claim should succeed, but it did indicate, in my opinion, in strong terms, that there were factors that could support such a claim. The appellant was an Indian national and he submitted a claim that there were insurmountable obstacles to his British citizen wife living in India. And the case relied upon expert evidence and detailed country information on various issues, such as medical care, gender violence, and cultural and linguistic difficulties. There were particular examples of violence against women of non-Indian origin. The judge accepted that these were all relevant factors. The case was also another example of where the court reiterated that the assessment of insurmountable obstacles was not a proportionality assessment, and all factors were required to be taken into account. I've highlighted a passage from the judgment where it states that there was relevant material that goes to the heart of whether a British citizen who has lived here all of her life, who does not normally travel and has certain medical conditions, will be able to cope with the considerable challenges of attempting to settle in India. Continuing with examples is the case of Menderis. This is one concerning cultural issues. A Turkish national who presented several factors in support of his claim, and the court held that the tribunals had failed to make important findings of fact and failed to consider the evidence with anxious scrutiny. For example, in this case, there were no findings on the duration of his relationship with his wife or cultural religious issues, such as his wife's objections to wearing the hijab, and that she was a non-Muslim. We'll see later from the Home Office policy guidance that cultural and religious barriers to relocation are relevant factors. The case also helpfully reminds us, when talking about anxious scrutiny, that the decision should show that every factor in the appellant's favour has been properly considered, and the court observed a finding from MN Somalia. I've referred to two cases of Kaur and Madibo. I've mentioned these to highlight the importance of detailed and supporting evidence. In both of those cases, on the face of it, there were several assertions being made, but without proper supporting evidence. And the court emphasised that there was a distinction between evidence and mere assertion, and considered that the stringent test in EX1 had not been met. The level of detail expected is illustrated by Kaur at paragraph 54, and I've set that out in the slides. And the court posed a number of questions that should have been considered. I'll leave that for you to read. And then moving on to Home Office policy guidance on EX1. This is recent guidance dated the 28th of January 2021 and worth considering, as there might be some helpful factors which can be used in support of an application or an appeal. The guidance provides a non-exhaustive list of factors, some of which I've set out in the slide, and just to highlight perhaps a couple. Whether the parties can lawfully enter and remain in the proposed country. The guidance states that where a person would be unable to gain entry into the proposed country, then this will be impossible to overcome. It also refers to where the sponsor has status as a refugee. That will prevent family life from continuing in the proposed country if the partner is of the same nationality. The guidance does not consider linguistic issues or a material change in quality of life amounts to an insurmountable obstacle unless it leads to a particular hardship. But even if these factors are not strong on their own, there's no reason why they could not form part of a cumulative assessment of all relevant factors. I've set out other factors, other faults, other factors to consider, which might be helpful when considering whether there are insurmountable obstacles. You could explore, for example, matters such as whether the parties will be destitute, their actual situation in relation to employment, housing, especially given the current circumstances of the pandemic, and whether there are other issues of dependency, just by way of example. Some of these issues tie in with the current situation, and I've referred to the FCO website and Travel Health Pro website, which might help on issues such as lawful entry, country conditions, impacts of the pandemic on healthcare structures, whether individuals are at a higher risk of exposure to COVID in certain countries, and particularly for those who are considered vulnerable. So as an example, if you were considering entry into Sri Lanka for an applicant's partner, entry is actually currently prohibited to non-nationals. And this has been the position as stated on the FCO website since at least July of last year. I'm now just going to move away from insurmountable obstacles and flag up some cases on children and section 117B6. Just starting with the case of Runa. Runa was a Bangladeshi national who entered the UK as a child on a visitor's visa, and she remained in the UK and later married a British citizen. Her appeal was allowed by the first-tier tribunal, but the Secretary of State successfully appealed. By the time of the upper tribunal hearing, she had 2 British citizen children. Paragraph 32 of Runa confirmed that section 117B6 is a standalone provision. And at paragraph 36, the Court of Appeal reiterated that when considering section 117B6, the focus was on the child, and the only question to be asked was whether it was reasonable to expect the child to leave the UK, and that the provision called for a fact-finding exercise. The upper tribunal in this case adopted an impermissible approach by asking questions such as whether there were insurmountable obstacles to family life outside the UK, or whether the children could remain with their father in the UK. This is set out at paragraph 41. And at paragraph 42, the court considered that this was fundamentally the wrong approach. The court also referred to the decision of AB Jamaica, where the court rejected the Secretary of State's submission that there was no need to consider section 117B6, where the child was not going to leave the UK. This is a single question that always had to be asked, and in such circumstances, the answer would be no. I've also referred to the cases of SD and UT, There are different types of cases, but worth highlighting because of the potentially relevant principles or arguments that could be used. So just starting with SD, I set out the headline points. SD involved an entry clearance human rights appeal by a partner applying to join her British citizen husband in the UK. They had two dependent dual British citizen Sri Lankan children who would accompany her. The upper tribunal discussed relevant principles concerning the children's British citizenship, that this was a relevant factor, but not necessarily a powerful factor, that the rights and benefits flowing from their other nationality should also be considered, and that there was no equivalent to section 117b6 relating to entry clearance applicants. SD's counsel highlighted the ironic position that by applying for entry clearance, SD was in a worse position than simply entering the UK illegally or overstaying, and thereby benefiting from section 117b6. The case is a difficult read. This was a situation where the sponsor was unable to care for the children by himself, and he attempted to care for one of the children, and he actually found that he couldn't cope, and the child was placed in care for several weeks. The situation was more complicated because the separation from his wife and children had caused the sponsor to suffer from depression, and his mental health was also affected. I've set out paragraph 104 of the judgment, where the upper tribunal considered the effect of deprivation was time-bound because the children could move to the UK when they were 18. One might think that that provides no comfort to the family who remain separated. Moving on to the case of Ut Sri Lanka, I flagged this case up because there are a number of factors considered in the proportionality assessment by the first year tribunal, which might be useful to consider. I will let you read paragraph 29 of that judgment. The court went on to say that the consequences had to be assessed in the real world. So this was not a matter of choice. The real consequences of the decision were that the family would be separated. UT is also a useful judgment because of some of the observations that are made by the court on appealing decisions from the lower courts, and that the court should not rush to find misdirections. I've just highlighted a few of the paragraphs in the slides. Turning now to the case of MY, which concerned a settlement application from a victim of domestic violence. In his covering letter, he also made a human rights claim. And the Secretary of State refused the settlement application and refused to consider the human rights claim, inviting MY instead to make a further application. The appellant's position was essentially that by refusing the application, the Secretary of State had also refused the human rights claim, and that MY was entitled to a right of appeal. The upper tribunal considered a number of cases and disagreed with the appellant. Paragraphs 56 and 57, which are set out in the slides, essentially said that the Secretary of State needed to engage with the claim and refuse it. And in this case, the Secretary of State had simply refused to consider it, and she was not obliged to engage substantively with the claim. Paragraph 59 of the judgment onwards considers the remedy and that any challenge to the Secretary of State in these circumstances should be by way of judicial review as opposed to appeal. It's troubling that on the present state of affairs, the Secretary of State can simply refuse to engage with the human rights claim and potentially deny the appellant his statutory right of appeal. It's also interesting to note that the upper tribunal appeared to have concerns about practical matters, such as becoming the primary decision maker in potentially a significant number of human rights cases. This is not the last word. The Court of Appeal has granted MY permission to appeal, and the basis of the grant is that it's well arguable that a human rights claim is refused, both if it's considered and rejected on its merits and if the Secretary of State refuses to consider it at all. Finally, to the requirements of Appendix FN not being met. And this is something that Jamil will talk about in more detail, but I've just flagged up Gen 3.2 in the case of Lal here again. The court reiterated that the relevant question when considering whether there were exceptional circumstances was whether refusing leave to remain would result in unjustifiably harsh consequences for the applicant or their partner, such that the refusal would not be proportionate. This involved not only identifying, assessing the degree of hardship, but also conducting a balancing exercise between the competing interests. At this stage, I'm going to pass over to Jamil to talk more about wider Article 8 arguments.
Thanks, Amarjit. What I want to try and cover in the time allotted to me, I mean, similar to the approach taken by Amarjit, I'm going to review some recent and some more historic case law with a view to trying to deal with a number of the issues that frequently arise when one considers Article 8 outside the rules. And the aim is that by the end of my section of the webinar, I hope that your toolkit for representing in Article 8 appeals will be restocked and refreshed. So starting, and I'm probably going to approach the issues that arise outside the rules using the steps in the Rasgar test, so going at it sequentially. And of course, the first question is going to be whether in fact family life or private life exists. A recent case was the case of Udine, and that case dealt with the question of whether family life exists. The factual background is quite interesting. Mr. Udine was a Bangladeshi national. He came to the UK as a child and he was abandoned here. He was treated as a trafficked child and he was placed in foster care. He made a claim for asylum which was refused, but he was granted leave as an unaccompanied minor. And he went on in due course to make a human rights claim which was refused. Central to his human rights claim was the argument that he enjoyed family life with his foster carer. That argument was not accepted at the first tier level, and it was also rejected on appeal by the upper tribunal. The evidence that was placed before the first tier and upper tribunals was that the appellant shared a very close relationship with his foster mother, and that she was found to have a commitment towards him and towards his development. But the tribunals found that in a situation where we have a foster carer and a foster child, that there cannot, as a matter of principle, be family life, because there is an element of a formal relationship arranged by the local authority at play. Now that argument was rejected on appeal by the Court of Appeal, and what the Court of Appeal emphasised is that the question of whether family life exists is one of substance, not of form. And there's a need to conduct a fact-specific analysis in any case where family life is claimed to exist. Not necessarily a novel concept, it's one that's been set out in many previous higher court cases, but it's one that I think is useful to remember, and it's very useful that the Court of Appeal has reminded the lower courts of that fact. And in fact, it's paragraph 40 that I've quoted on the slide that I would say is of most relevance. In terms of looking at Article 8 in the Kagatha sense, when we're talking about dependency, what we're looking for is effective, real or committed support. There's no requirement to provide, to prove exceptional dependency. Dealing with the point that was at the heart of the case in Udine, the mere fact that a family relationship may be in the foster care context does not mean that family life cannot be found. Again, it's a factual question. And a useful reminder of the principle that was found in HK Turkey, the mere fact that an individual attains majority doesn't mean that he can't enjoy family life with his parents. In fact, we can see in the final line of Roman numeral 3 there, no negative inference should be drawn from the mere fact of the attainment of majority. So again, it's a fact-specific analysis. We need to look at the substance and not the form. Moving on to the second stage in the Rasgar test, and it's a 2015 case, so it's not a new case, but it's one that I like to quote in my skeleton arguments. It's one that I think is a useful case to rely on. It's fact specific, so it only really is of relevance in cases where the individual facing removal is in a relationship with a British partner. But it comes from the Supreme Court, and it's from Lady Hale, making the point that the interference with the Article 8 rights of the British partner in a case such as the one that you might be dealing with is substantial. In fact, it's been found in a previous case, the case of Keeler, to be colossal. And the reason I think it's worth using this case in your submissions in a human rights claim or in your drafting in an appeal is because, of course, what we're then going to go on to do under proportionality is to strike the fair balance. We're going to conduct the balance sheet approach. And by pointing to the fact that the interference in this kind of case is a substantial one, and that the British partner in that case is facing the unenviable dilemma that's described in this paragraph, is, in my opinion, an important step in setting the scales before we go on to strike that fair balance. And you'll have noted the language I've just used there. I've used that language on purpose because, going back again to some older cases for a moment, just to set the context of the fifth step in the Rasgar test, the question of proportionality, this is the language that is being used. This is what the judge needs to be thinking about, or what the Home Office needs to be thinking about on application. So in GM, the question is, when we're looking at Article 8 outside the rules, how is a fair balance to be struck between the public interest in the individual's removal and their private interests, their family life or their private life, in the importance to them and their family members of that family life? So it's all about fair balance. And there is no extra step of exceptionality that needs to take place, or no extra test that needs to be met. It is a balancing exercise. And, an old case, the case of Hesham, but a very, very important case to remember when we're dealing with looking at proportionality outside the rules. Because at paragraph 83 of Hesham, Lord Thomas encouraged judges to use the balance sheet approach that's widely used in areas of law like family law. You draw a balance sheet, and on one side you put the pros, and on the other side you put the cons. So what's weighing in favor of the public interest and what's weighing in favor of the private interest. And finally, another older case that's of use, I find, the case of Core, which was an upper tribunal case. The then president, Mr. Justice McCloskey, made the point that in every balancing exercise, it's important that the judge properly prepares the scales before going on to determine the issue of proportionality. I find that the three cases that I've just referred to are very useful, first of all, in framing your arguments on proportionality to the Home Office or to tribunals, but also when you analyse decisions of the first tier, dismissing an appeal, and you want to see whether the court's fallen into error. I find that it's useful to use some of these terms, approaches in working out whether the judge has made a mistake. So, for example, just looking at Core, I've often seen where judges fail to consider or fail to take account of a consideration that I drew to their attention as weighing in the positive side of the balance, so in favor of allowing the individual to stay and enjoy their family life. And that consideration hasn't been taken account of by the tribunal. The argument that you run then on appeal is, well, the judge failed to properly prepare the scales because he or she left out an important consideration when conducting the balancing exercise. As I say, I appreciate that these principles are not novel, but it's important when we go on to look at some of the other issues that can fall on the positive and negative side of the balance sheet, that we have in mind the task for a judge considering an Article 8 appeal outside the rules. You'll obviously be well aware of Section 117B of the 2002 Act. And I don't want to just spend this webinar going over old principles, but I would like to try and look at some of those principles with a fresh pair of eyes. And one of those, of course, the first is 117B1. So we know that it's in the public interest that effective immigration control is maintained. The courts have been very keen to emphasize that it's not simply enough for judges to pay lip service to this public interest consideration. Invariably, weight needs to be attached to the fact that it's in the public interest that immigration control is maintained. That, however, is not to say that this particular public interest consideration can't be diluted, or even in a rare case, I would say, found not to apply to a given case. And I think it's important that when you're looking at the facts of your case, you're thinking about things that might reduce the weight that should be attached to Section 117B1, so the fact that the maintenance of effective immigration control is in the public interest. And a way of doing that, and I'll come on to look at this in more detail later in the slides, is to look at factors that might suggest that the Home Office has not operated its immigration system in respect of your client in an effective way or in a proper way. So we're looking at things like delay and historical injustice. And as I said, I'll come on to look at that in more detail. And also it's worth pointing out if your client is one of those who has complied with immigration rules throughout their stay and is not somebody that has breached immigration law. That's not to say that 117B1 won't be placed in the negative side, but perhaps less weight will be attached to the public interest consideration in 117B1. 117B2 and 3. And by now, a well-known principle that financial independence and the ability to speak English are neutral factors. But it's worth bearing this in mind when it comes to preparing appeal bundles, for example. In Repair, it was made clear that the fact that your client might be able to speak English, might be financially independent, does not, or is not worthy of positive weight in the positive side of the balance sheet. However, if they don't speak English, or they're not financially independent, or at least if there's not evidence before the tribunal of those facts, negative points can be put in the negative side of the balance sheet and can weigh against your client in the proportionality balance. So it's very, very important that when we're preparing appeal bundles that these 2 points are being addressed, even if by addressing them we're only hitting a neutral factor. However, the court does also say that the fact that an individual can speak English and is financially independent may be relevant to the strength of private and family life. In practice, I'm not sure how far we can take that argument, but don't forget it's important to put in the evidence proving that your client is financially independent and can speak English. Now, sections 117B4 and 5, and I'm going to spend quite a bit of time looking at these particular provisions. And because I'm going to do that, I've actually put them up on the slides. I know that you'll be well aware of them, but it's worth just rereading what they say. So section 117B4 is all about little weight being attached to private life or a relationship with a qualifying partner, which was established when the person was in the UK unlawfully. And 117B5 is all about little weight being attached to private life, established when the person's immigration status was precarious. Now, common mistakes I find that are being made are perhaps returning for a moment to 117B4. Sometimes practitioners and judges are under the misapprehension that little weight should be attached to family life that's established when a person is in the UK unlawfully. We have to be very clear, obviously there's private life, but it's also just a relationship formed with a qualifying partner. So this provision does not say that little weight should be given to family life that's established by a person who is here unlawfully. So we have other kinds of family life relationships other than a relationship with a qualifying partner that are excluded from consideration under 117b4. For example, a relationship with a partner who's not a qualifying partner. So a qualifying partner, according to 117d1, is somebody that's British or is settled. So if we're dealing with a relationship here that's formed with somebody that might be in the UK with limited leave to remain, section 117b4 doesn't apply to them. If we're dealing with family life between a parent and a child, if we're dealing with family life between an adult child and an elderly dependent relative, 117b4 doesn't apply, provided we can show that there's family life. It's worth bearing that in mind. Again, it's a tool that I think can be used when reviewing decisions by the tribunal and looking at whether an incorrect public interest consideration has been placed in the negative side of the balance. And then a similar point can be made about section 117b5. A common error that's made is that little weight is attached to family life that's established by a person when their immigration status is precarious. 117b5 only deals with private life. So if we're talking about family life that's established when somebody is here with precarious stay, they're not caught by 117b5. And that's actually what the Court of Appeal in Rupiah emphasized in a number of paragraphs that I placed in the slides. And I'll just give you a few moments to have a read through what was said. So you can see that the court was very clear that the little weight provision in section 117b4 only applies to private life and only applies to a relationship formed with a qualifying partner that was established when the person was in the UK unlawfully. So it doesn't apply to general family life, and 117b5 does not apply to family life established when somebody's in the UK with precarious leave. That's also emphasized again at paragraph 37. Now, before I move on to this particular slide, it's worth thinking about the facts of GM, because the facts of GM actually exemplify the point that I've just made. The appellant in that case had formed a relationship with somebody that had limited leave to remain in the UK, and she had done that when she was in the UK as a student. The court emphasized that in that factual scenario, 117b4 and 117b5 don't apply. So there's no requirement on the tribunal to attach little weight to the family life that's created in those circumstances. The court went on at paragraphs 39 and 40 to address the relevance of an individual's knowledge about the precariousness of their stay to the question of family life. And despite everything I've said about 117b4 and 5, there is case law from the Supreme Court and from Strasbourg that says that an individual's knowledge, their subjective knowledge of their right to be in the UK, and therefore of their right to be here and go on to establish family life, is an important consideration to assessing the proportionality of their removal. And in essence, what the court is saying here is that, for example, a couple that has held a reasonable expectation that they were permitted to stay together in the UK, that reasonable expectation is something that might make the individual who's facing removal, their removal, disproportionate. And on the other hand, if a couple knew that they were creating family life in circumstances where one person didn't have the right to remain in the UK to enjoy that family life, that's something that might weigh against them and suggest that their removal is proportionate. So we have to look at it in two ways. We've got the statutory considerations, and then we've got some higher case law. The way I deal with it is I obviously make clear what Parliament has decreed, and I focus on that. And if I'm given this point, I try and steer the discussion back to the fact that Parliament's considered this, and Parliament has decided not to make the point that that it's in the public interest for individuals in this situation to be removed beyond what's in 117b4 and 5. In the case of Birch, the idea that an individual's subjective knowledge of their immigration status is relevant to the issue of proportionality, and is relevant to the amount of weight that should be attached to a relationship or private life under 117b4, was found to apply equally to both 117b4 and 117b5. And the facts of Birch are very interesting. Mrs. Birch was a Jamaican overstayer, and in 2007, she was deceived by somebody who was impersonating an immigration officer. She paid that person £3,000, and in return, she was given a stamp in her passport that said she had indefinite leave to remain. She proceeded under the misapprehension that she had indefinite leave to remain until 2015. And in that time, she established a relationship, and in due course went on to discover that, in fact, she didn't have indefinite leave to remain and had to make an application to regularize her stay. She made a human rights claim. The Home Office refused that human rights claim. And although the Home Office accepted that she had been deceived, when the matter came before the tribunal, the public interest consideration in section 117b4 was found to apply. So little weight was attached to her relationship with her partner. The court in Birch made the point that because Mrs. Birch was proceeding under the genuinely held misapprehension that she had indefinite leave to remain between 2007 and 2015, when she established her relationship, weight could be attached to her relationship, and she wasn't caught by the requirement in 117b4. And then just drawing the discussion on 117b4 and 117b5 to a close by reminding you of, again, by now, some very well-known case law, but just reminding you that the tribunal is not placed in a straitjacket by the public interest considerations. Under section 117a(2a), the tribunal has a limited degree of flexibility to depart from 117b4 and 5 and attach weight to private life and a relationship with a qualifying partner in certain circumstances. And the Supreme Court approved what Lord Justice Sales had said at the Court of Appeal level, that the generalized normative guidance in 117b4 and 5 may be overridden in an exceptional case by particularly strong features of the private life in question. But it's worth making clear that in order to make the argument that the tribunal should exercise the flexibility it has, we need to be placing before the tribunal evidence and arguments that show why our case is an exceptional case and why there are strong features in our case that justify a departure from 117b4 and 5. And another well-known argument, but one that again is worth reflecting on, little weight involves a spectrum. So you want to be able to make the argument that your case raises enough grounds to argue that a lot of little weight should be attached to the private life in question, and therefore that lot of little weight outweighs the public interest. So we need to put evidence and argument together to try and show why that's the case. Moving on now, so away from the public interest considerations, to address three issues that generally can arise when we're arguing about Article 8 outside the rules. The first is to do with the Chickwamba line of case law. Now, again, I don't want to go over trite law necessarily, but it's worth, again, just reminding ourselves of what the Chickwamba Principle said, or what was said in Chickwamba, such that we've drawn a principle out of it. So what was said by Lord Brown at paragraph 44 in Chickwamba is that it seems to me that only comparative rarely, certainly in family cases involving children, should an Article 8 appeal be dismissed on the basis that it would be proportioned to more appropriate for the appellant to apply for leave from abroad. So you'll know the situation. We argue on appeal with reference to evidence showing that we would meet all of the requirements to return to the UK for entry clearance as a partner, say. And we're saying to the court, look, in these circumstances where there's going to be prolonged separation of partners or of a father from a child, it would be disproportionate to make the individual leave the UK to make an entry clearance application. And we use this particular extract in Chickwamba as the basis for that argument. Now, Chickwamba was then positively applied in the case of Hyatt, and it's worth noting that at paragraph 30A, what was said was that a dismissal of the claim on the procedural ground that the policy requires that the applicant should have made the application from his home state may, but not necessarily will, constitute a disruption of family or private life sufficient to engage Article 8. And then looking at C, whether it is sensible to enforce that policy will necessarily be fact sensitive. Lord Brown identified certain potentially relevant factors in Chickwamba. They will include the prospective length and degree of disruption of family life, and whether other members of the family are settled in the UK. So the reason why I've read those two particular extracts to you is because we're going to go on to see how the upper tribunal has recast the Chickwamba principle. But in fact, I wouldn't say that the upper tribunal has in fact recast it at all. It simply said what's being said here in Hyatt. And I can show that by looking at the first instance of the recasting, the case of Chen. So in Chen, the upper tribunal said that Lord Brown was not laying down a legal test in Chickwamba. So we can't argue that that it's necessary to look at whether or not it's going to be comparatively rare for it to be proportionate for an individual to have to leave the UK to make an entry clearance application in a case involving children. So there's no legal test in Chickwamba. And moreover, what we're looking at in the first point of the head note is that there may be cases in which there are no insurmountable obstacles to family life being enjoyed outside the UK, but where temporary separation to enable an individual to make an application may be disproportionate. Again, the use of the word may. So it's fact sensitive. And in all cases, the individual has to place before the respondent, before the Home Office, the evidence to show that the temporary separation is going to disproportionately interfere with protected rights. I don't think Chen actually changed the way in which the Chickwamba principle was formulated, but then in practice, what one was seeing was in the first tier, Chickwamba arguments were succeeding less and less, I think. So there was an onus on appellants to place before the tribunal the evidence to show that temporary separation was going to cause detriment to a partner that has to stay here or to children. And then just jumping on to the case of Eunice, we have another potential recasting of the Chickwamba principle. This is a more recent case where the upper tribunal emphasized that simply being able to demonstrate that the Chickwamba principle applies in your case doesn't mean that there's no public interest in the individual's removal. Rather, what one has to do is the balancing exercise, weighing the public interest considerations alongside the fact that in a given case, the Chickwamba principle might be at play. Again, I don't think that that really does change the way in which the Chickwamba principle was first formulated in 2008 or how it was applied in 2012 in Hyatt. And I think it's important to make that point and to remember and remind the tribunal of the case of ECHR, because in ECHR, the Chickwamba principle was affirmed by the Supreme Court. But the Supreme Court didn't say that in every case where it can be shown that an entry clearance application would succeed, that there would be no public interest in the individual's removal. They said that there might be no public interest. So it's not a question of, I think, simply relying on the Chickwamba principle and saying we win. The task has always been, but moreover now, it really must be to place the argument that's run under Chickwamba in the context of a balance sheet approach, dealing with the public interest considerations, placing before the tribunal the evidence that shows that there would be a detriment to a family if an individual has to leave the UK to make an entry clearance application. Now, there's one potential other dimension to all of this at present, because of the Home Office's coronavirus concession on individuals having to leave the UK to make applications they would normally have to make from outside the UK. At present, I've certainly been arguing that because we can show in an appeal that an individual would succeed with an entry clearance application and they can't leave the UK because of obstacles placed in their way due to COVID, and the Home Office policy guidance, which is on this slide, it's disproportionate to dismiss their appeal. It's disproportionate to find that they should be removed from the UK. And I've had some success with that argument, and I know that other colleagues have had some success with that argument. However, I worry that casting the argument in that way may be the wrong way to be looking at it, because I think if the higher courts got hold of this point, what they would probably say is Section 117B1 makes clear that the maintenance of effective immigration control is in the public interest, and it's not right for certain individuals to jump the queue by winning, using this argument in an appeal and not having to pay a fee. I think it's better that this argument is cast on the basis of the Home Office having to draw the tribunal's attention to their policy, and the fact that your client might meet that policy should be determinative, or should be a very weighty factor in the positive side of the balance sheet when considering proportionality. And I'll come on in my final slide to deal with that point. Two final issues to address. I mean, one is the issue of historical injustice. And this issue really deals with circumstances where the Home Office's wrongful operation of the immigration system has caused a detriment to your client, or has led to your client remaining in the UK and developing a private life and a family life because of the Home Office's failure to make a decision, say, in an application, or because of the Home Office's error in your client's case, and the relevance of that to proportionality. So the clearest example is delay, and the well-known case of EB Kosovo. The point that's made towards the end of this extract is a relationship that might be entered into in a situation where an individual is in the UK with precarious leave or unlawful leave will start from the position that it's going to have a sense of impermanence. But if months pass without a decision to remove being made, and these are the final few lines, and months become years and years succeeds year, it is to be expected that this sense of impermanence will fade. The expectation will grow that if the authorities had intended to remove the applicant, they would have taken steps to do so. So this principle is best summarized by Lord Reed in Agyarko. If there's a protracted delay in the enforcement of immigration control, that may well diminish the cogency of the public interest in removal. So what you want to look for in your case to see whether it's something that can be argued is an application that's made and then many years go by without a decision being made. What you don't want to the facts that don't allow for this sorts of argument is an individual that's in the UK making repeated fresh claims, say, that are being refused. You want some wrongdoing, some delay in this example on the part of the Home Office. And just to draw that idea into the spotlight, in a more recent case, the case of Patel, most of the judgment in Patel deals with the difference between a historic injustice, which arises, say, in the Gurkha context, and a historical injustice. Here, the relevant point is a historical injustice. So as I said, something that might result as a result of the wrongful operation by the Home Office of her immigration functions. Examples are given, delay, or the failure to give somebody the benefit of a policy, or the wrongful accusation that an individual cheated in his English language test, so the ETS example. What you can do if you're able to establish that one of these historical injustices have taken place is use that fact, well, first establish the fact, and then use that fact to diminish the cogency of the public interest. So to water down what's in the negative side of the balance sheet, and within, looking back at 117B1, to water down the weight to be attached to 117B1. And then finally, to bring my part of the webinar to a close, the Home Office has been found to be under a duty to draw its policies to the tribunal's attention. And I think in the context of COVID, where the Home Office has been operating a number of policies that it publishes on its website, many of which are relevant to family life cases, whether it's to do with the income threshold, whether it's to do with whether or not an individual has to leave the UK to make an application. It's really important to bear in mind that these policies need to be brought to the tribunal's attention. If your client's represented, obviously, then you're under a duty, really, to draw the tribunal's attention to the policy. But if you're not, and you look at a determination where it's not been drawn to the tribunal's attention, use this case and make the argument that the Home Office was under that duty and failed to discharge it. That's all I wanted to cover. We have tried to pack in quite a lot into this webinar, and as a result, we're not going to have time for questions during the webinar. Instead, you'll see our contact details on this page, and please feel free to email us and we will answer any questions that you have. Remember that our webinar series is continuing. It's continuing next week. I think the next one is next Thursday. So if you haven't signed up, please do sign up. Don't forget, you can watch any of our previous webinars by going onto our website and going to the Goldmine page. And finally, I just wanted to say thank you for joining us for this webinar. I know it's in the middle of the day. And so thank you for joining us, and I wish you a good afternoon.